Mr. Davies, welcome to our Medibox platform. Your report on new generation trade agreements and their implications for social rights, public health and sustainable development is just adopted in the Parliamentary Assembly session. So let me start with the definition and your understanding when you say new generation trade agreements.
Well, what we're talking about primarily is the new free trade agreements between the EU and Canada, and also the free trade agreement between EU and United States. That one's called TTIP, the other one's called CETA. And there are opportunities, and we welcome more trade, but there has been a number of concerns expressed over the ability of transnational companies to sue democratically elected governments for laws they pass to protect our environment, our public health, our rights at work. So the new court system, the investor court system that's being proposed, is better than the old system, but it would allow big companies to sue governments. And in particular, we've seen these sort of arbitration panels used, for example, in Egypt to stop people introducing the minimum wage. We've seen them in Mexico to actually punish and fine and sue the government in Mexico for introducing tax on fizzy drinks in order that they were putting that forward in order to curb diabetes, because the average person in Mexico actually consumes a litre of Coca-Cola, fizzy drinks, a day. We've seen Philip Morris, the tobacco manufacturer, try to sue Australia for plain packaging to contain the number of people who are dying from smoking. And we've seen big fracking companies, in particular Lone Pine, trying to sue Canada when Quebec put a moratorium on fracking. So what we're saying now in the Council for Europe is we can't allow massive companies to intimidate and punish democratically elected governments for passing laws which are designed to protect the public health, the environment, and the human rights of our citizens. And therefore, what we've agreed today is that these courts, investor court system, should only go ahead if and only if individual countries have the right to withdraw from the court system, not the trade agreement, but the court system with a year's notice, be it with 6 or so years of protection for existing investors. Secondly, that those courts must be bound by the judgments of the human rights judgments of the European Court of Human Rights. And thirdly, that any damages should be limited to actual damages incurred, as opposed to fantasy future alleged profits that have been lost by a change in taxation or restriction on activity of companies to protect the citizen. That's what it's about. So we've ended up with a conditional situation which gives very strong sort of ironclad guarantees to the citizens that we will do everything we can to protect our democracy and human rights and the rule of law, for which we stand in the Council of Europe as we move forward tentatively with these trade agreements.
Thank you for joining us, Mr. Rapporteur.
Thank you.